Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Here we are again. My name is Gustavo Vieira. I am professor of international law at the Federal University for the Latin American Integration. In this morning of 17th July 2020, we have the continuation of the presentation realized by Professor Concepción Escobar Hernandez. She did a presentation yesterday on the immunity of the state officials on international law and by the domestic jurisdictions. So, Professor Concepción Escobar Hernandez, she is professor of international law at UNED. She is legal advisor of the Minister of Foreign Affairs, of the Ministry of Foreign Affairs on Spain and the Ministry of Defense, and she's also professor at the Diplomatic Academy of Spain. She was also part and head of several Spanish delegations for international organizations and conferences, of which the Rome Conference on the Statute of International Criminal Court and the Kampala Conference on the amendment of the Rome Statute, of which she was president of the drafting committee, are worth mentioning. And as a member of International Law Commission of the United Nations, she is reported on this issue. So, Professor Concepción Escobar Hernandez, it's a pleasure to be with you again. It was very clarifying, your presentation yesterday, and the distinguishes, for those who were not with us yesterday, the clear and the emphasized distinguishes among state immunity and the immunity of state officials and the approach on the domestic jurisdiction. Professor Escobar, the virtual floor is yours. The speaker is not on.
Thank you. Now is it working? Yeah. Good morning, everybody. Bon dia. Thank you, Professor Vieira, for your kind introduction of myself. I would like only to say something. I no longer the legal advisor of the Minister of Foreign Affairs. I was the legal advisor for 8 years, but not at that moment. Well, as I said yesterday, today I plan to refer to the work of the International Law Commission on Immunity of State Officials from Foreign Criminal Jurisdiction, the topic to which I am a special rapporteur. And I would like also to make some comments about the relation between the work of the ILC and the work of the ICC with regard to this topic. I will start with the work of the ILC. The ILC included the topic immunity of state official from foreign criminal jurisdiction in its long-term program in 2006 and decided to appoint a special rapporteur in 2007. The first special rapporteur was the Ambassador Kolodkin, who submitted 3 reports to the Commission in 2008, 2010, and 2011. The Secretariat elaborated at the same time an interesting memorandum on the topic issued in 2008. The Commission and the Subcommittee of the General Assembly considered those reports in 2008 and 2011, but unfortunately, no consensus was identified by the Commission with regard to the most of the elements contained in the report submitted by Special Rapporteur Kolodkin. I was appointed as a special rapporteur in 2012, and at that moment, my main concern was to provide the Commission with an instrument to address the topic on a new way, in a structured and productive way. For this purpose, I submitted to ILC a working plan that was endorsed by the Commission. Following this roadmap, I have submitted to the Commission 8 reports. The last one was prepared to be discussed this year in order to allow the Commission, if it was possible, to adopt the first reading of the whole of draft articles in 2020. Unfortunately, due to the pandemic, it has been impossible for us to meet in Geneva, so we have been obliged to postpone our debates to the next year. On the basis of the 7 first reports, the ILC has been able until now to approve 7 draft articles. The last one, the draft Article 7, devoted to exceptions, was adopted by a majority of votes in 2017. I will say something about that later. At the present, there are some other articles on the table of the ILC drafting committee not yet adopted. In particular, draft Article 8 to 17th devoted to procedural provisions and safeguards, and draft Articles 18 and 19th final clause devoted in particular to set out the model of relationship between the draft articles and the rules governing the proceedings before the ICC. Well, due to the limited time, I would like to sum up in a concise manner the work of the ILC until today, including the issue of international crimes, which was the object of great interest yesterday because of the questions from the students. In addition to that, I will add some comment, as I said before, to the relationship ICC-ILC. Well, let me start with some comments related to the scope of the topic before the ILC. Draft Article 1, adopted by ILC in 2013, refers to the scope of the topic, saying that the topic is the immunity of state officials from foreign criminal jurisdiction. And at the same time, this article states that there are not covered under the form of a without prejudice clauses. The draft article are without prejudice of other rules of international law applicable to immunity of state officials. With regard to this scope of the Commission, I would like to underline two aspects. First, the decision of the Commission of not include the immunities from civil jurisdiction and the immunities from international criminal jurisdiction within the scope of the topic. And second, the inclusion of a non-prejudice clause related to other forms of immunities from criminal jurisdiction recognized under international law and qualified as special regimes, diplomatic and consular immunities, or immunities enjoyed by military forces of a state. So the specialized regime to which I referred yesterday. The Commission purpose is to adopt a draft articles containing the general legal regime of immunity of state officials from foreign criminal jurisdiction, letting aside the existing special regimes and the regime applicable to immunity from international criminal tribunals. However, I would like to draw your attention as well to the open debate among the members of the ILC about whether the Commission must take or not into account in its works the existence of rules of international law on immunity that are applicable before international courts and tribunals. This issue has been raised as well by several states at the CID committee, and I will come back on this issue in the second part of my presentation. But as a preliminary comment, I would like to draw your attention on the fact that international rules and international practice, having been developed before international criminal tribunals, have been considered by the Commission in order to illustrate the practice which constitute the basis of the work of the Commission. The same approach has been followed regarding immunity from civil jurisdiction. So you can find a lot of reference to both practices in my reports. Having said that, and in order of a better understanding of the work of the Commission on this topic, let me mention at the outset the key elements constituting the basis for the proposed new regime, even if I will build more on them later. These key elements are the following. First, the recognition of a dual regime devoted to immunity ratione personae and immunity ratione materiae. I'm sure that you remember my explanation yesterday about this issue. Second, the definition of the normative elements of immunity ratione personae and immunity ratione materiae, subjective element, material or substantive element, and temporal element. The same elements for both kind of immunity, ratione personae and ratione materiae, but having different meaning in each type of immunity. Third, the exception to immunities, and fourth, the procedural dimension of immunity. For sake of clarity, I will address each of them in an autonomous manner, even though there are remarkable connections between each other. Let me start by the distinction of immunity ratione personae and immunity ratione materiae. As I propose in my preliminary report and in my second report, the Commission has agreed on instituting a distinction between immunity ratione personae and immunity ratione materiae. This distinction, well established in the legal literature, was included in the reports by the former Special Rapporteur Kolodkin as well, but only with a descriptive purpose. In a different vein, the Commission in 2013 has considered these two types of immunities from a normative perspective, taking into account that each type has different normative elements and at least in some aspect could be governed by different rules. This agreement opens the possibility of establishing two different legal regimes, each of them applicable to one type of immunity from criminal jurisdiction. And the most important, this approach opened the possibility to establish some rules related to exceptions to immunities with regard at least to the immunity ratione materia. Although the Commission has decided not to define for the moment the two types of immunity, even if I have submitted such a definition in 2013, it has been accepted as a general understanding the existence of three elements that must be considered in order to distinguish the immunity ratione personae and immunity ratione materiae. I have mentioned yesterday those elements or criteria, so I think I will not I will don't need repeat now again. This distinction between immunity ratione personae and immunity ratione materiae has been taken into account in the commentaries to draft Article 4 and 6. However, some reasons remain. I suggest you that if you are interested in this topic, you have to take into account that the Commission usually take on the following basis. We adopt draft articles, draft commentaries, draft conclusion, and after that, we adopt commentaries with regard to each specific draft article, draft commentary, draft conclusion. So the commentaries on that are the source for well understand the work of the commissions. It is when you read, I take advantage to say to you that when you are reading the work of the commission, please not forget to read the commentaries, because otherwise it's very difficult to understand the meaning of the draft articles on others. Well, in 2013, the Commission adopted two draft articles containing the normative elements of the first kind of immunity, the immunity ratione personae. Draft Article 3, which refers to the subjective dimension of immunity, limits the scope of this type of immunity to the persons exercising one of the posts or functions pertaining to the so-called Troika, the head of state, the head of government, and the Minister for Foreign Affairs. Although some members of the ILC expressed at that moment different points of view with regard to this matter, some of them in order to extend or others in order to reduce the number of state officials enjoying immunity ratione personae, finally, a general consensus was reached in favor of a restrictive approach to this kind, to the number of state officials covered by immunity ratione personae. Moreover, the Commission expressed its view in favor of the applicability to other high-rank officials of the rules of immunity for special missions, the rule to which I make some reference yesterday. So doing, high-rank others than the Troika could enjoy some immunities, but not the immunities of the general regime of immunity ratione personae set out in the draft article. The consequences of such a decision are very relevant, and if you are interested, we can deal with at the end of my presentation. With regard to the substantive scope of immunity ratione personae, the Commission has maintained a traditional approach, attributing immunity to all acts of head of state, heads of government, and Minister for Foreign Affairs during the period of exercise of their mandates, whether there are private acts or acts performed in an official capacity. So, as one of you among the students said yesterday, the Troika members enjoy absolute or full immunity. I prefer use the word full, even with regard to international crimes. I will come back to this issue later. With regard to the temporal scope of immunity, I must underline the Commission's agreement on considering the immunity ratione personae, and that immunity ratione personae, ends on the date when the term of the official finishes. This immunity cannot be extended after this date, not even for acts performed in an official capacity, which will no longer be covered by immunity ratione personae. After the end of their terms of office, the member of the Troika only can be covered by immunity ratione materiae regarding the acts performed in an official capacity during their term of office. Now I move on the immunity ratione materiae region. In 2014 and 2015, the ILC has addressed the normative elements of the immunity ratione materiae, in particular the concept of state officials and the concept of how to perform in an official capacity. In addition, the temporal element of this kind of immunity has been considered. The definition of a state official, the subjective element, adopted by the ILC, reads as follows. State official means any individual who represents the state or who exercises state functions. By this definition, the ILC desire to offer a comprehensive concept of a state official covering both the individuals enjoying immunity ratione personae and immunity ratione materiae. But of course, this definition has a special relevance with regard to the immunity ratione materiae. On the other hand, the phrase who represents the state or who exercise state functions express the need for a link between the state and its official as a sine qua non requirement to enjoy immunity. In this regard, attention must be drawn to the fact that a state official may fulfill both requirements to represent a state or to exercise state functions, or only one of these. The reference to representation is of special importance with regard to the head of a state, head of government, and Minister for Foreign Affairs, because these three office holders represent the state in its international relations simply by virtue of their office directly and with no need for specific powers to be granted by the state for that function. However, the reference to representation of the state may also be applicable to state officials other than so-called Troika, in conformity with the rules or acts of the national system themselves. Lastly, it must be noted that the separate reference to representation of a state as one of the criteria for identifying a link with the state makes it possible to cover certain persons, such as those head of a state who typically do not perform state function in a narrow sense, but who must certainly represent the state. See for example, the King of Spain. He doesn't perform any state function, with the only exception of the general representation of a state. State functions must be understood in a broad sense to mean the activities carried out by the state. This designation includes the legislative, judicial, executive, or other functions performed by a state. Consequently, the state official is the individual who is in a position to perform these state functions. The reference to the exercise of state functions defines more precisely the requisite link between the official and the state. In any case, whether an state official is representing the state or not, or is exercising state functions or not, must be determined on a case-by-case basis. Even though the definition, as I said before, of a state official is a general one and covers both immunity ratione personae and immunity ratione materia, this definition has a specific significance for immunity ratione materia. In this regard, the International Law Commission has considered that it cannot use the technique of identification eu nomine of state officials, as in the immunity ratione personae, in particular because of the diversity of the positions of the individual to whom immunity may apply, and on the variety of national legal systems that determine which persons are their officials. However, the Commission has included in the commentary to draft Article 2, paragraph E, by way of example, a list of persons having appeared in national and international case law regarding immunity from jurisdiction. That list includes a former head of state, a minister of defense and a former minister of defense, a vice president and minister of forestry, a minister of interior, an attorney general and a general prosecutor, a head of national security, a former intelligence service chief, a director of a maritime authority, an attorney general and various lower ranking officials of a federal state, a prosecutor and his legal assistant, a detective in the attorney general office and a lawyer in a state agency, military officials of various ranks, and various members of government security forces and institutions, including the director of Scotland Yard, border wards, the deputy director of a prison, and the head of a state archives. As you can see, the list of officials could be considered as state officials is very broad, and we need to analyze case by case if one specific official fulfill or not the requirements to which I have referred previously. Finally, it must be taken into account that immunity ratione personae could cover also the former members of the Troika, whose term of office has come to an end with respect to acts performed in an official capacity during such term of office. Finally, I would like, in addition to that, I would like to call your attention on the fact that a state official only enjoy immunity ratione materia when he is acting as such. This phrase expresses the special link between official and state required to apply immunity and exclude the possibility to consider covered by immunity of several activities, several acts performed by an official, a state official when he is working in a private, in its private capacity. The second normative element of immunity ratione materia is the concept of art performed in an official capacity. The Commission has adopted the following definition. An act performed in an official capacity means any act performed by a state official in the exercise of state authority. With regard to this definition, it is possible to make the following remarks. First of all, the ILC has decided to adopt a definition as simple as possible, useful for identifying any act capable to be qualified as performed in an official capacity in a case-by-case way. Second, The Commission has used the expression in the exercise of state authority to reflect the need for a link between the act and the state. The link is needed not only between the state official and the state, but also between act performed in an official capacity and a state. In other words, the aim is to highlight that it is not sufficient for a state official to perform an act in that capacity in order to for it automatically be considered as an act performed in an official capacity. On the contrary, there must also be a direct connection between the act and the exercise of state functions and powers, since it is this connection that justifies the recognition of immunity in order to protect the principle of sovereignty. In this regard, the Commission believes that in order for an act to be characterized as an act performed in an official capacity, it must first be attributable to a state. However, this does not necessarily mean that only the state can be held responsible for the act. If you remember the explanation I give to you yesterday about the distinction between immunity, state immunity and immunity of state officials. On the contrary, the attribution of the act to the state is a prerequisite for an act to be characterized as having been performed in an official capacity, but does not prevent the act from also being attributed to the individual in accordance with the single act dual responsibility model. In this context, the Commission has taken the view that state functions include, once again, the legislative, judicial, executive, or other functions performed by the state. It must be underlined that it is not possible to conclude that an unlawful act as such cannot benefit from immunity rationem materia. Several courts have concluded that unlawful acts are not exempt from immunity because they are unlawful, even in cases when the act is contrary to international law. The Commission has taken the view that an unlawful act as such, and the ILC has decided to use the wording state functions and not the word sovereignty of the expression governmental authority, taking into account the views expressed by several members of the Commission about the difficulty to define those concepts. Whether the state authority exists or not must be analyzed case by case. However, as in the case of the concept of a state official, the commentary of the draft article offers some examples of activities which had been considered in the practice as covered by immunity. This illustrative list is as follows. In general, national courts have found that the following acts fall into the category of act performed in an official capacity: military activities or those related to the armed force, as related to the exercise of police power, diplomatic activities and those related to foreign affairs, legislative acts, including nationalizations, the process of nationalization of property, acts related to the administration of justice, administrative acts of different kinds, for example, expulsion of aliens or the flagging of vessels, and acts related to public loans and political acts of various kinds. Moreover, the immunity of state officials has been invoked before criminal courts in relation to the following acts that were claimed to be committed in an official capacity: torture, extermination, genocide, extrajudicial executions, enforced disappearance, forced pregnancy, deportation, denial of prisoner of war status, enslavement and forced labor, and acts of terrorism. Such crimes are sometimes mentioned in nomine, while in other cases, the proceedings refer generally to crimes against humanity, war crimes, and serious and systematic human rights violations. Second, the courts have considered other acts committed by members of the armed force or security service that, in opinion of those courts, do not fall into the aforementioned categories. Such acts include ill treatment, abuse, illegal detention, abduction, offenses against the administration of justice, and other acts related to policing and law enforcement. In a number of cases, a contrary census, national courts have concluded that the act in question exceeded the limits of official functions or functions of the state and was therefore not considered as act performed in an official capacity. For example, some courts have concluded that the assassination of a political opponent or act linked to drug trafficking do not constitute official acts. From a different perspective, national courts have generally denied immunity in case linked to corruption, whether in the form of diversion of misappropriation of public funds or money laundering, or any other type of corruption on the grounds that such acts are distinguishable from the performance of state functions protected by international law in accordance with the principle of sovereignty and diplomatic immunity. Following the same logic, courts have not accepted the act performed by a state official that are closely linked to a private activity and for the official's personal enrichment, not the benefit of the sovereign. This kind of acts are not covered by immunity. A particular issue has arisen about whether international crime can be considered or not as an act performed in an official capacity, but I will address this issue in connection with the exceptions to immunity. Well, the third and last normative element of the immunity ratione materia is the temporal element. In this case, suffices to notice that immunity, the International Laws Commission has defined the immunity ratione materia as a permanent one, establishing in draft Article 6 that this immunity continued to subsist after the individuals concerned have ceased to be state officials. With regard to the limits and exceptions, I would like to call your attention on the fact that limits and exceptions to immunity constitute one of the most controversial elements of the topic. This controversial nature has been expressed both by the ILC members during the debates within the Commission and by states in their statements at the SID Committee. However, former Special Rapporteur Kulotkin considered in general that it is not possible under contemporary international law to identify any exceptions to immunity from criminal jurisdiction of state officials. The opinion of the ILC members is divided, and some members of the Commission have expressed their strong opposition to such a general conclusion from Special Rapporteur Kulotkin. In fact, the issue of exceptions to immunity has been present since the beginning of the ILC works on this topic. A similar division of opinions is also present in the statements produced by states at the SID Committee. The different responses to this issue focus in particular on the existence of an exception with regard to international crimes. In favor of the inapplicability of exceptions, the main argument has been that the act of an official susceptible to be attributed to a state is an act of a state, and that for that reason, the act and its author benefit from state immunity. A specific reading of the arrest warrant case judgment from the International Court of Justice, has been alleged as a basis for this assessment. In addition, against applicability of exception, it has been argued that even if international practice shows that immunities don't apply before international tribunals, immunities before domestic jurisdictions and immunities before the International Court and tribunals must be dealt with separately, and that the institution of exceptions to immunities would operate only with regard to international courts and tribunals. On the opposite side, those in favor of the applicability of exceptions to immunities allege the differences between state immunity and the immunity of a state official, and the existence of a trend in contemporary international law to recognize the international criminal responsibility of individuals for certain crimes which cannot be covered by immunity before the international criminal tribunals. On my own view, let me express some thoughts yet included in my fifth report to the Commission, even in a telegraphic way. First of all, I think that the qualification of an act as performed in an official capacity doesn't mean that the act is in itself are exclusively an act of a state. As I have stated previously in my fourth report, the theory one act, two responsibilities applies to immunity as well. And as a consequence, the state immunity and immunity of a state must be distinguished. That said, the rules governing state immunity and immunity of state officials may be different, and in particular, a limitation or exception can be applied to immunity of state officials in case of an international crime, even if that exception couldn't be applied to state immunity. Second, immunity of state officials and individual responsibility have a link which can't be ignored. It is true that immunity is, in principle, a procedural rule in state responsibility, which is a substantive one. This distinction has been underlined by the ICJ, both in the arrest warrant case and in the immunities of a state case. In the last mentioned case, in order to exclude the use cogens as an exception to state immunity. Without entering in the debate about the controversial statement of the ICJ in this case with regard to the use cogens, it must be said that such a statement must be tackled in a more cautious way in the case of immunity of state officials, in particular because in most of the cases, the strict application of the immunity on the basis that it doesn't mean any statement on individual criminal responsibility has, as a consequence, the impossibility to deduce the criminal responsibility of an state official for the most grave, most serious crimes under international law, in particular in the case of immunity ratione materia. Absolute immunity from foreign criminal jurisdiction for every state official and for every act performed on his or her official capacity is incompatible with other rules and legal principles of international law protecting international legal values such as human rights. In addition, such absolute immunity can have as a result the absolute impossibility to prosecute a state official or former official with regard to the most serious international crimes, such as genocide, crimes against humanity, or war crimes. In particular, cases where they can be prosecuted, when the official can be prosecuted before an international tribunal or before any other national court, the risk is that absolute immunity without any exceptions, could mean impunity. Even if after the ICJ judgment on immunities of state cases, use cogens could not be considered as legal foundations for exceptions to immunities, It must be underlined that this normative category don't constitute the sole basis to proceed to identify the existence of exceptions to immunity based on respect for rules and essential values of international law, of international law. On the contrary, international practice offers significant elements in support of exceptions. Let me mention, for example, the Genocide Convention, the Torture Convention, the Disappearing Conventions, or the Rome Statute on International Criminal Court, or even several national legislations on state immunities or on implementation to the Rome Statutes, which have included clause on exceptions to immunity of state officials because of the international crimes. The Spanish Act on Immunity of State and International Organization of 2015 constitute a good example of that trend. On the other hand, the analysis of the practice of the judicial practice on immunities, in particular the national one, permit us to conclude that it exists a trend in favor of certain exceptions based on international crimes, at least with regard to immunity ratione materia. On the basis of these remarks, I submitted to the Commission in 2017 the draft Article 7 devoted to limitation and exceptions. Draft Article 7 was the object of agreed and strong debate among the members of the Commission in favor of exceptions, the majority, and against exception, the minority. During that debate, all the arguments mentioned above were considered, and finally, the Commission adopted provisionally reviewed draft Article 7, according to which immunity ratione materia, and I quote, immunity ratione materia from the exercise of foreign criminal jurisdiction shall not apply in respect of the following crimes under international law: crime of genocide, crimes against humanity, war crimes, crime of apartheid, torture, and enforced disappearance. With regard to the scope of these crimes, the Commission decided that no need to define them exists, but in order to avoid any possible legal insecurity, decided at the same time to adopt a list containing the main international instruments defining the listed crimes. This list, who include, for example, the Rome Statute and other instruments, has been object of some criticism, and probably the ILC must come back on it on the second read. At any rate, I must underline that these limits and exceptions apply only to immunity ratione materia. That means that head of state, head of government, and Minister of Foreign Affairs continue to enjoy immunity even with regard to these crimes when they are in office. Of course, they will be submitted to draft Article 7 when their terms ends, in the case they could enjoy any immunity ratione materia because of the acts performed in an official capacity during their term. Even if I suggest in my original proposal to include other exceptions to immunity, the Commission considered that it was not necessary to include corruption and crimes committed in the territory of the foreign state as exception, because without any doubt, they were not covered by the concept of acts performed in an official capacity, or they were against international law. As I said at the beginning of my presentation, the Commission, under a formal petition of one of its members, adopted draft Article 7 by vote, 21 in favor, 8 against, and 1 abstention. It has been the first time in more than 2 decades that the ILC need to have a vote, and as a consequence, the decision have had a great impact in the debate at the SIG committee and the doctrine. So the issue of immunities continue to be in the core, at the core of the debate, of the work of the Commission, and we will address against in the future. The last part of the work of the Commission focused on the procedural rules and safeguards, to which I would like to make some to refer now. The procedural elements include different kinds of issues: the definition of jurisdiction and the identification of acts qualifying as jurisdiction, for example, detention, provisional arrest, provisional measures, the identification of the time when the immunity has to be considered by 4 authorities, the rules applicable to invocation and waiver of immunity, and last but not least important, the procedural safeguards. I have included between procedural safeguards the duty to notify to the official state of the intention to exercise jurisdiction, the exchange of information, some forms of mutual legal assistance, and of course the possibility to use the institution of the transfer of proceedings between the state, the forum state and the state of the official. The purpose of the procedural safeguards are to build of an atmosphere of confidence between the forum state and the state of the officials, to set out some instruments in order to facilitate a fair balance between all the values, principles, and interests in presence in a case involving immunity, the interest of the foreign state, the interest of the state of official, and of course, to try to avoid controversies between state affected. The need for a close relationship between exceptions and procedural safeguards had been expressed by several members of the Commission and some states, in particular in the direction that if we include exception, the Commission has to be able to offer to a state some instruments to avoid the possibility of political prosecutions or illegal ingerence in national, in domestic matters. Well, as I said before, the Commission intends to finish the first reader this year. Probably we will be able to adopt that next year, but we are in a very difficult situation now nowadays. At any rate, it will be impossible to finish all the work of the Commission during the present quinquennium. Well, let me say something about the relationship between immunity of state officials from foreign criminal jurisdiction and international criminal tribunals. The relationship between the immunity of state officials from foreign criminal jurisdiction and international criminal tribunals have been present in the work of the Commission from the very beginning of, at a very early stage, having been mentioned in the documents that provided the basis for the inclusion of the topic in the long-term program of the work of the Commission. It has been mentioned also in the memorandum of the Secretariat, and this issue has been included in all the reports prepared both by Special Rapporteur Kolotkin and from myself. The first element to take into account is the following. The distinction between foreign criminal jurisdiction and international criminal jurisdiction is reflected in the scope of the topic, because the commentary because the paragraph 1 of the draft Article 1 provisionally adopted by the Commission read as follows. The present draft articles apply to the immunity of state officials from the criminal jurisdiction of another state. The Commission has clarified that scope in its commentary to the articles, saying that the Commission decided to confine the scope of the draft articles to immunity from foreign criminal jurisdiction, that which reflect the horizontal relationship between states. This means that the draft articles will be applied solely with respect to the immunity from criminal jurisdiction of another state. Consequently, the immunities enjoyed before international criminal tribunals, which are subject to their own legal regime, will remain outside the scope of the draft articles. But the most important is the following. This exclusion should be understood as meaning that none of the rules governing the operation of immunities before such tribunals are to be affected by the content of the present draft articles. On the basis of that first commentary, I decided in my fifth report to include a proposal for one specific exception to be included in the draft Article 7. The original proposal read as follows. Paragraph 1 and 2 are the paragraph in which there were listed the crimes not covered by immunity, and saying that that immunity exception applies only with regard to immunity rationale materia. Well, paragraph 1 and 2 are without prejudice to the obligation to cooperate with an international court or tribunal, which in each case requires compliance by the foreign state. During the consideration of the report by the Commission, that proposal had given rise to an interesting debate, during which some members noted that the reference to the obligation to cooperate with international criminal tribunals had not place in a draft article devoted to limitation and exceptions to immunity and should simply be deleted. Some of them may express reference to the fact that the inclusion of such a provision at that time could prejudice a question the scope of the obligation to cooperate with the International Criminal Court, which at that time was sub judice before the court in the case concerning the International Criminal Court, in the case concerning the non-cooperation by South Africa in the arrest and surrender of then President al-Bashir of Sudan. Other members considered, on the contrary, that paragraph 3 of draft Article 7 proposed by the Special Rapporteur should be retained, since the Commission's work on the present topic should not alter the jurisdiction of the International Criminal Court and the obligation freely assumed by state parties to Rome Statute. For other members, the content of the paragraph was useful and should be included in the draft articles, although they felt at that moment that draft Article 7 was not the most appropriate place to do so, and that it was probably preferable for it to be included under a more general formulation that could apply to the draft articles as a whole. Some of them noted that it was perhaps more appropriate to include that content in the part of the draft articles devoted to the procedural aspect of the topic. In the meanwhile, the international scenario regarding the exercise of the competence by the International Criminal Court faced two important or two relevant facts. First, because of the evolution of the case against al-Bashir, of the former President al-Bashir, the ICC have adopted judgment, an interesting judgment in the Jordanian case. The Jordanian case is very similar to the South Africa case, but Jordan decided to appeal the decision taken by the International Criminal Court, saying that Jordan has not cooperate with the court, and to ask the Security Council and Assembly of State Parties to take the due measures, to adequate measures. Well, because on the basis of the appeal introduced by Jordan, the Commission, the ICC has been obliged to take some decisions on the relationship between immunity of state officials before national courts and immunity of state officials before the international court. At the end of the day, the issue is easy. It's very easy to understand. The issue, the true issue is the interpretation of the draft of the Article 98, to which I referred yesterday on my answers to a question from students, and the relationship of this kind of this article with Article 27 of the same Rome Statute. But at the same time, I would like to call your attention about the fact that the African state decided 2 years ago to ask, to open the procedure to ask the international to ask the General Assembly to demand, to request the International Court of Justice to issue an opinion about the meaning of draft of Article 98 and the scope of the duties of a state on the basis of that article. Well, in this basis, on the basis of this new situation, the approach of the ILC to the relationship between immunity of a state official from foreign criminal jurisdiction and the work of the ILC was stopped. And now we have to resume the treatment of this issue this next year on the basis of my 8th report. On my 8th report, I suggest not to enter on the issue of the system of an exception, as the section I propose in my 5th report, but to look at the relationship of between ICC and national or domestic courts with regard to the immunity of state officials from another perspective. It is from the using the tools of without prejudice clause. On this basis, I have submitted to the Commission a new draft Article 18, reading as follows. The present draft articles are without prejudice to the rules governing the functioning of international criminal courts. What is the purpose of this draft article submitted to the consideration of the ILC? First of all, ensure that no rules included in the draft articles will damage or harm the full competence of the International Criminal Court, but at the same time, avoid some kind of oppositions to the inclusion of some kind of reference, some reference to the international criminal tribunals in the report, because through these draft articles, we are saying that the draft articles adopted by the Commission can't damage the existing rules applicable in the international criminal tribunals, but without made any pronouncement, without take any decision about the fact, the following issue. I'm summing up my presentation because it was longer. In case to go more directly, if one national tribunal doesn't respect the immunity of state officials under international law because the state is obliged to cooperate with the International Criminal Court, these kind of acts are domestic criminal jurisdiction or international criminal jurisdiction. As you probably know, the answer to this question from the ICC has been very clear, but for me very controversial. The ICC said that the exercise, the decision to arrest one head of a state because a previous request from the ICC is a form of exercise of the own jurisdiction of the ICC, is not a domestic criminal jurisdiction act. So it's not covered by immunities. Well, I think that the argument, even if it is interesting, if it's an intelligent argument, I can agree fully with that argument, but for not to be obliged to take position with regard to this issue, which is it is outside of the mandate of the Commission in this topic, and at the same time with the intention to less open the issue, because it's an issue that will be probably will be fixed in the future. The best way is to suggest the draft article 18 saying that is without prejudice. The draft article is without prejudice to the rules governing the functioning of international criminal tribunals. Well, thank you very much. I speak more than I intend to do it, and I'm open to any question from the audience. Thank you very much.
Thank you very much, Professor. I think those latest observations were very interesting also, and we have several questions. I would also ask you to, if possible, to come back to the issue of unlawful official acts realized by in official capacity, and the relationship with ultra vires acts. When a state official realize some activity, there is out of his attributions, out of his competence, or unlawful. And if it's, of course, there is a long discussion on international responsibility of state, on ultra vires acts, but also in immunity of state.
Sorry, I can't hear you. I can.
Oh, sorry.
I lost the sound. Yeah.
Okay.
voice. Okay.
I would. You didn't listen any part?
No. I listen most of the part. You are interested about the unlawful act issues and the ultra-virus issues. That's it?
Right.
Okay,
That's
perfect.
it. And we have other questions. Leticia Maciel asks, in the case of a minister which was exonerated and used a diplomatic passport to enter in other country, does he has immunity because he was indicated to be the director of World Bank? If so, which type? It's a very recent case of our Minister of Education, former Minister of Education. So,
excuse me, Professor, could you repeat the question, because I lose some nuance.
okay, I read as it is.
Okay.
The case of a minister which was exonerated and used a diplomatic passport to enter in other country, does he have immunity because he was indicated to be the director of World Bank? If so, which type? He entered as minister and he avoided the time of the quarantine
okay.
because he entered with a diplomatic passport. And in the same day it was published, he was not minister anymore. Well, the second question, Amanda Lemos. Good morning, Professor Hernandez, Escobar Hernandez. I am writing my bachelor thesis on immunity of heads of state, and I admire your work a lot. My question is, when writing the report as special reporter, did you envision that the Security Council could have such a power to relativize immunity rationi personi in regards to prosecution of head of states for international crimes before the ICC? And the third question, Luis Felipe Santana, who did a question yesterday. Professor Hernandez, in your opinion, which are the challenges to a future convention on immunity of state officials? I would also ask you if you could include in this answer which were the most hot points, the most difficult points to achieve kind of a consensus in the International Law Commission.
Thank you very much. I will start to answer the fourth question at the end of the finally. Yeah, with regard to the unlawful acts and ultra-virus act, there are of course some issues very deeper and debate in the Commission because they are. They have two phases. On one hand is the issue of responsibility, and on the other hand, the issue of immunities. I think that the unlawful acts and ultra-virus acts approach for immunities can't be the same that the approach for from responsibility. First of all, with regard to the unlawful acts, where I think that if we are speaking about immunity of a state official from foreign criminal jurisdiction, it's clear that in principle, the acts which could benefit the officials, the state officials benefiting, enjoying immunity could be prosecuted by an unlawful act, criminal act. That is clear. Otherwise, it is the success of jurisdiction doesn't exist. If he exercised, the state official exercised and of perform an unlawful acts, these unlawful acts could provoke or could generate the responsibility of a state, because it's an unlawful act. But at the same time, the responsibility for the individuals. From the perspective of immunity, well, a state can say, well, it's an unlawful act. For that reason, is not an act performed in an official capacity. I can agree, absolutely. I can agree, because look, for example, the irregular detention of a person abroad of the state of the firm, of the state of the official, or torture, or for example, to some forms of ill treatment. They are unlawful, but they continue to be acts performed in an official capacity. It is possible that the responsibility of a state it doesn't exist. It depends. It depends on the application of the rules of responsibility. But anyway, it's an unlawful act, and we have to see at that kind of act from the perspective of an act performed in an official capacity. With regard to the ultra vires act, of course, ultra vires act are act performed in an official capacity for the purpose of responsibility, for state responsibility. But it's not so clear that there are state performed in an official capacity for the purpose of immunity. You know, for example, illegal detention, forcing pregnancy. They could be ultra vires acts, are not under, but it doesn't mean that there can be. There are not acts performed in an official capacity, but sometimes tribunals, national tribunals, have to consider that from the perspective of immunity of state officials. For example, torture committed by the head of a state, directly committed by the head of a state. War crimes directly committed by the head of a state, the head of government, or the Minister of Foreign Affairs. Of course, there are ultra vires acts, but that seems that because under the rule of international relations, with international responsibility, they are acts for act of a state. That means that they are act committed in personal, in an official capacity, and that for that reasons immunity applies. I don't know if I respond to your question. Well, with regard to the second question, well, I think that we have to make a distinction between to be a holder of a diplomatic passport and to be a holder of a specific office in a state. We can be holder of a diplomatic passport, and we enter in a country on the basis of under the rules of the diplomatic passport, and for that reason we could enjoy some kind of immunity. In this case, it's not a matter of immunity of state officials. Look, I think that it was different, taking into account the issue the case you have referred. But it is there are no relation between the passport and the condition of state official. I don't know if I can express the idea. The immunity of state officials, at any rate, would exist in case, taking into account the real post occupied by that person, not because he is holder of one diplomatic passport or not. Of course, the issue is that if he's holder of one diplomatic passport because he is indicated that he holds some specific post, specific is assigned, is an element, is for the evaluation or for the foreign state authorities to assess if he is or a state official. But the day after, when they know that is not longer a minister, is clear. The signal has no value. I don't know if I have answered to the concern about the student. With regard to the immunities, ICC and Security Council, I'm not sure to have been understood the question, but my main my immediate reaction is that when we are speaking about immunity of state officials from criminal foreign jurisdiction, so in the meaning of the work of the International Law Commission, the Security Council has no rule has no role to play in this framework. But it is true that sometimes when we are speaking, we are thinking about the immunities before ICC, the capacity from the Security Council to waiver immunity of one of a head of a state is the question is related, of course, with the al-Bashir case. Yeah, the debate is the Security Council has the capacity to waiver the immunity of one head of a state. I'm not sure. To be honest, I'm not sure. I think that Security Council has not such exorbitant power, because that means that Security Council has by itself the capacity to modify international law in force. Yeah, because if immunity of state officials or the immunity of the head of a state is an institution under customary rule, the Security Council has such as normative power to modify this rule. My answer is no, of course. But the issue, I think that the issue could be set from a different perspective. Security Council by adopting the resolution asking the ICC to open an investigation on the crimes committed in Sudan, has the power, because that has the power to impose to Sudan all the duties contained in the International Criminal Court, in the statute of the International Criminal Court. Because it's the power. It is the power of the Security Council. It's not he's not changing. The Security Council in this case is not changing the international law. It's not modifying international law. It's only decided that a certain rule of international law must be applied to this situation, and that is the competence of the Security Council under the Article 16 of the Rome Statute. Well, that means that Security Council have removed the immunity of al-Bashir. Not. That means that the Security Council obliged to anyone, to Sudan in this case, and of course to state members of the Rome Statute, state parties to Rome Statute, to apply in whole the Rome Statute, including Article 27. That means that no immunity is not possible to allege any immunity before the International Criminal Court. Well, the fourth, and thank you so much for your kind words about the second question, the kind words about my work at the Commission. And with regard to the future convention, well, the possibility to to adopt a convention on immunity of a state official from foreign criminal jurisdiction has been raised by several members in the Commission, who are, all of them are against exceptions. And the same possibility has been raised by states who are also against exceptions. I want to mention them, but that is the main element. Well, it is possible to adopt a convention on this topic. It is. It is because at the end of the day, when the Commission work on the basis of draft articles, the Commission is preparing a draft for. We can understand that the Commission are working in order to prepare a draft for a future convention. That was the case of crimes against humanity, but it's not necessarily always that, you know. It is possible, of course. It is available. The possibility is it is a real opportunity to have a convention. I'm not convinced. I'm not opposed to start the negotiation for a convention, but I'm not sure that the General Assembly, in particular the Sixth Committee, who is very, very conservative body, and where the political issues have a high weight, I'm not sure that the Sixth Committee was ready to open the negotiation for such a convention. Look, it was the same last year with regard to the crimes, a future convention for crimes against humanity. And second, if the possibility for a convention, the usefulness of this convention, I'm not convinced neither. Why? Because I'm not sure that in a future convention on immunities, the issue of exceptions could be included. Unfortunately, I think that is clear. And you ask at the same, for that reason, I'm not convinced about the usefulness of a future convention, even about the availability to negotiate a future convention. To finish, my assessment about the future convention is related to the hot points. What are the hot points? I think that for the topic, the hot point is the exceptions. It has been always the most controversial issue during the more than 3 decades, when the Commission, three quinquenniums of the works of the Commission on this topic. And of course, I think that this hot point need to work a little more in order to get some kind of consensus. And on this way, I think that the proposals for procedural safeguards and procedural provisions could be a good element to make to get a balance who facilitate the consensus. Sorry for the long explanation.
You've been working for such a long time on this issue, so it was, I think it was very brief, very summary explanations. Thank you very much. We have another question only by Fabio Farinella. Hi, dear Professor Hernandez. Had the Commission dealt with acts of state-sponsored terrorism and the immunity related to those who participate?
It's very easy to answer not. We didn't deal with that in the past, and I think that we will not deal in the future. But anyway, in order to decide if an act of terrorism could be covered by immunity, my first reaction is no. But we need to explore more about the relationship between the so-called terrorist and the state. Could they be considered qualified as state officials? Sometimes yes, sometimes no. It depends. And second element, we have to identify if this act of terrorism could be qualified as act performed in an official capacity. And finally, we need to think about the content, the nature of the act, because some of the act of terrorism could be covered by the categories of crimes against humanity. Genocide is more difficult, but war crimes and other international crimes included in draft Article 7. So in this case, the immunity will not apply to this kind of acts. Well, but it is not under the on the hands of the Commission decision. This issue.
Perfect. Our time is over. I'd like to thank you very much for those such clear, deep explanations. I think it was very interesting to also to understand the deep consequences under international politics and international law of this development in international law that International Law Commission is preparing and by your capacity. So, Professor, thank you very much. If you kindly could send us the reports, I will share with the students the organized folder, Google Drive folder. So it will be very useful for us. And if you want to make some final remarks.
Well, it's very difficult to make some final remarks. Of course, I will send you the reports and other documents that could be of interest for students, for the students. But for one final remark, who is outside of the whole explanation I give you during this 2 days. Now, immunity, the topic of immunity of a state official from foreign criminal jurisdiction has obliged the Commission to think about its mandate and about the meaning of codification and progressive development. Only two words. Well, of course, the immunity of a state official from foreign criminal jurisdiction is a controversial issue, both from political and legal perspective, of course. But does it mean that the Commission must avoid this kind of topics? That is, well, look at the more recent practice in the Commission, and we are facing the risk to avoid the more controversial topics, focusing only in more technicalities, the more technical topics, without the relevance from the perspective of the international legal system. Well, my answer is very clear. No, I think that the Commission must continue to perform its mandate on the spirit which the Commission was built in 1948. The Commission has been established in order to facilitate, to cooperate with the state, to facilitate to a state for fixing difficult issues of international law, not only for preparing academic documents. And second, the Commission has to limit its activity to codification and putting aside the development of international law. No, my answer is the same. No, I think that the Commission, the added value of the work of the Commission is the capacity of the Commission to cooperate in the development of international law and to participate in the process of development of international law, taking it into account the international order, legal order as a whole, not putting aside and not forgotten core elements for the international legal system as the values and principles of international law. And that's all. I'm sorry, I speak too much again. Thank you very much to all of you, and thank you for your kind attention. Thank you for the very, very interesting questions you have made. And well, of course, you can feel free to contact me, you or the students and everybody, if you have some additional interest on this issue. Thank you very much. Muito obrigada.
Thank you, Professor Concepción Escobar Hernandez. I think it's very clear your deep contributions to the development of the international rule of law here with these final remarks. Have a very nice day, and thank you very much for all your contributions and your disponibility, availability to share with us your view on international law and in the development of international law. Thanks. Have a nice day. Goodbye.
Goodbye. Bye.